Hi, everybody, and welcome to CompliancePoint's 2019 regulatory update. My name is Matt Cagle. I'm the Vice President of Operations at CompliancePoint. Also joining me from the CompliancePoint side is Paul Gibson. He is the manager of the Customer Engagement Practice. And we're really excited to have Marissa Boynton joining us today from Latham & Watkins. Marissa has a ton of experience in the topics we're going to discuss today, including privacy and data security, compliance and program management, advertising and marketing practices, consumer protection, and the Foreign Corrupt Practices Act. Marissa has had experience in front of the Department of Justice, the SEC, the Federal Trade Commission, states attorney general, and other government agencies. And I don't know how she does it, but when time permits, Marissa also volunteers her time doing pro bono legal work, some of it related to cybersecurity and data security. She has clients in a variety of industries, including consumer, healthcare, retail, professional services, and the technology sectors. Hopefully, most of you are familiar with CompliancePoint, but if not, just want to give a quick overview of us. So our mission is to help you responsibly engage your customers in the marketplace, and we do that by helping you manage risk when it comes to the privacy of your customers, the security of the data that you collect, and then ultimately the way you work with your vendor network when engaging your customer base. We help companies with areas such as TCPA and mobile compliance, cloud compliance, cybersecurity, and lately a lot of work in the privacy space, helping our clients prepare for GDPR and now the California Consumer Privacy Act. So today we want to start out by looking at the federal level. We'll review what happened in 2018, both from a regulatory change perspective, as well as we'll look at a few enforcements and some lessons learned. We'll then perform the same analysis at the state level and call out a few items companies would want to keep an eye on as we roll into 2019. We then want to look at privacy. So 2018 was really the year of privacy. We're going to look at the impact of the GDPR and the ripple effect we're starting to see in the U.S. We're also going to look at a particular U.S. law that is now being enforced more actively. And then as time permits, we're going to take some questions at the end. So if you have questions as we go through today's presentation, please enter those into the chat box and we will do our best to respond to as many as possible. So as mentioned, we want to start off today by looking at the federal activity in 2018 and give you a look ahead as to what we expect in 2019. And Paul, I know there were a couple key regulatory changes that we wanted to call out. First being the reassigned numbers database.
Yeah, thanks, Matt. And we want to talk about a couple of key regulatory changes, both of which have to do with the FCC. The first one is a big one, and that is that the FCC has approved the creation of a reassigned number database. And this will allow carriers to notify the FCC that a number is eligible for reassignment, meaning it will move from one party to another party.
Yeah, and Paul, I think this is key for companies and really a win for the industry. It might not feel like it once they have to pay to access this database, but as we'll see in a moment, TCPA lawsuits are still very frequent, frankly rampant. And companies have been asking for a way to determine when the holder of a cell phone number changes to avoid that wrong party contact issue that's led to a lot of these lawsuits. So frankly, the fact that this will exist and they have the ability to access it and suppress against it can really help facilitate compliance.
Yeah, it'll be able to allow a company to prove and demonstrate that they are attempting to contact the people they want to contact.
Yeah. And we do want to point out the details around how this is going to be accessed and managed are still being worked out. But as we look ahead to the rest of 2019, this is something companies need to keep track of, and we'll definitely notify the customer base once this list is available for access.
Yeah. And one final point on that, the expectation is that the price and the logistics of accessing this list will be very similar to the national do not call lists. So the next one we do want to talk about is the fact that the FCC has now deemed the wireless messaging services as an informational service. Previously, wireless messaging was considered a telecommunication service. Again, it is now a information service. And what that does is it really just reduces the complexity that the carriers face if they are attempting to block a text message from reaching a customer because they think it is a spam message or a fraudulent message. Due to the carrier's current rules, because it is a telecommunications message, they are not allowed to block that message. Now that wireless messaging has been deemed as an informational service, they are more empowered to block any message that they think is a fraud or a spam text message.
Yeah, so this is definitely something to keep an eye on. We've seen an impact from some of the call labeling and call blocking technology that now exists in the space, both from the wireless carriers and some third-party apps. And there definitely have been some impacts on companies' ability to communicate with customers. And so people need to track this and be aware of how it's going to be handled so they can respond accordingly to make sure that their legitimate messages are able to go through. So next, kind of following up on what we said about the reassigned numbers database and the importance of that, we want to talk about a little bit more about why. I think everyone's very familiar that TCPA lawsuits have steadily increased, and as you can see, it's leveled off a bit, but Paul, it looks like they're still pretty heavy.
Yeah, in recent history, the TCPA lawsuits, the total number has remained pretty stagnant, but overall it is increased exponentially when you look at, say, a 10-year period. And the information you see here today is from WebRecon. They do a good job at tracking the TCPA lawsuits that are filed. Matt, I know you've got some thoughts as to why you think this TCPA has continued to increase.
Yeah, I think there's a few key points. In 2013, we had some of the first changes to the TCPA, and we started to see a slight increase. Then there were additional changes in 2015, and we continued to see the rise in the amount of lawsuits filed. You couple that with the prevalence of cell phones. So nearly everyone's got a phone in their hands these days, and frankly, being called or texted on that device, we believe consumers feel it might be a little more invasive in nature. So when you look at the ubiquity of cell phones, the regulatory changes, and just the awareness amongst consumers when it comes to some of these lawsuits and some of their rights under the TCPA, we think has led to that increase. While it's declined a bit, it's clear that the amount of lawsuits is still at a very high level, and this is an area that companies need to be aware of. Again, once that reassigned numbers database is available, that will help with compliance. So the next thing we want to look at is FTC complaint data. So the FTC does a great job of making their complaint data available each year, and Paul and team dug into these numbers and have some thoughts on and some takeaways.
Yeah. So each year the FTC does publish a data book that outlines the different complaints as well as some other statistics regarding the National Do Not Call list and other items pertaining to the FTC. This graphic shows complaints made by consumers to the Federal Trade Commission. Basically, they are attempting to point out that they have received what they think is an illegal robocall or live call from a company. And they get about 500,000 complaints per month. And robocall, you can see, is depicted in blue, is the most prevalent in these complaints. The reduction of debt is obviously the highest level of complaints, and we also think that's because debt collection calls and reducing debt, it's a sensitive area, and consumers are more likely to complain about sensitive subjects. But there are certain reputable industries that are presented here: vacation and home energy and solar energy, alarm services. They're still prevalent, and that means that consumers are making complaints about reputable industries, reputable companies, because they have reason to believe that a call shouldn't have been made. It's unknown what the threshold is where the FTC would look into or start to look into a company in terms of the volume of complaints. But we do think that the high number of complaints shown here today, especially within the reputable industries, highlights the need for having adequate record keeping, monitoring, and just overall the ability to create a defensible position.
Yeah, and if we've learned anything from working with companies and their customers, it's that consumers do not know all of the nuances of the rules and the exemptions that are available. And so if they get a communication that they're not happy about, they may complain even though that communication was completely legal. So the point for everyone today is if all your communications are compliant, that's great. But complaints can and will occur, and you need to make sure that you have the compliance framework and the records to demonstrate your compliance posture if needed. So now I'm going to ask Marissa to walk us through some enforcements and lessons learned that we saw at the federal level.
Thanks so much. So we'll start off with the much awaited opinion by the DC Circuit that came out last year. So in March of last year, the DC Circuit issued its long-awaited decision in ACA International with the FCC, which struck down key elements of the FCC's 2015 declaratory ruling and order interpreting the TCPA. In its 2015 ruling, the FCC determined that because the statutory definition of an automatic telephone dialing system refers to the capacity to dial a random or sequential numbers, any equipment used to place calls or send text qualifies as an auto dialer if it has virtually any potential future capability to dial such numbers. In its decision last year, the DC Circuit held that the FCC's broad definition of an ATDS is arbitrary and capricious and required the FCC to reconsider its definition. The DC Circuit largely focused on the fact that the FCC's interpretation has the potential to sweep in all smartphones. The court also noted that the FCC's earlier orders addressing predictive dialers covered only equipment that could create and dial lists of numbers without human intervention, but the FCC's 2015 ruling suggested in places that even equipment that doesn't create a list, but simply dials from an externally supplied set of numbers qualifies as an ATDS. So subsequent to the opinion, the FCC sought comments on what is an auto dialer, and we're still waiting from a decision from the FCC on this point. And I'm going to talk a little bit more in a minute about what has happened since this opinion, because certainly the landscape is not settled, and there were significant additional decisions later in the year last year, which were not consistent and have created a split in the circuits. So the next point I'm going to address is that multiple courts upheld the text stop to opt out. So last year, multiple courts dismissed cases on the grounds that the plaintiff had attempted to opt out using unreasonable revocation methods. So these are what people call opt-out evaders. So these people were going out of, these plaintiffs have gone out of their way to not use the mechanism provided by the caller. In October of last year, the Ninth Circuit upheld the district court's ruling that a plaintiff failed to plausibly allege she had reasonably revoked her consent. So in coming to this decision, the court relied on a couple of different factors, including the availability of the one-word opt-out procedure. So the company had offered this ability for a consumer to text stop to opt out. The court also relied on the fact that the plaintiff had failed to use this one-word opt-out mechanism, instead texting back some convoluted attempt to not get caught by the opt-out mechanisms set by the company, and the company's notice to the plaintiff that did not understand her non-standard messages, where a court held that the plaintiff knew that the caller had a reasonable revocation method, such as texting stop. So this was a significant win for companies who are implementing these kinds of mechanisms in below for these opt-out evader type plaintiffs who are looking for ways to bring TCPA lawsuits against companies for not following their opt-out attempts.
Yeah, and Marissa, what we've recommended to clients there is that increase their filters to look for words beyond the directed opt-out language, just to be safe, such as stop or quit or opt-out, and also potential misspellings of that word. But yes, we agree that the results of those courts was definitely beneficial for clients.
Great. So if we want to move on to the regulatory changes that may be coming down the pipeline in 2019. So on February 4th, a representative from New Jersey introduced the Stopping Bad Robocalls Act, which is intended to strengthen the TCPA and the FCC's fight against robocalls. Representative Pallone originally proposed this law last year on June 7th, 2018, along with Senator Ed Markey, who was the author of the original TCPA. So the previous version of the bill didn't make it past the House Energy and Commerce Committee, but now that the Democrats are in power, Pallone is again trying to pass the legislation to amend the TCPA. So a couple of significant aspects about the proposed law. It would redefine the term robocall to mean a call or text sent using equipment that makes a series of calls to stored telephone numbers, including numbers stored on a list, or to a telephone number produced using a random or sequential number generator, which is a broader definition of a automatic dialer than we've seen by some courts, but it has attempting to address that by creating an exception. So the exception is for a call made using only equipment that the caller demonstrates requires substantial additional human intervention to dial or place a call after a human initiates the series of calls, or using, and also included in that would be a call or text sent using an artificial or pre-recorded voice. It also would expand FCC enforcement authorities against violations in the TCPA. It would allow consumers to revoke consent that had previously given to receive calls at any time in any reasonable manner, regardless of the context. And it would codify that a reassigned number database that was talked about earlier to put robocallers on notice when a telephone number has been reassigned to a new customer who has not consented to automated call or text. And will also include a safe harbor provision for callers using the database and complying with several requirements. So on January 18th, Senator John Thune, a Republican from South Dakota, he's the chairman of the Subcommittee on Communications Technology, Innovation, and the Internet, and Senator Ed Markey reintroduced the Telephone Robocall Abuse Criminal Enforcement and Deterrence Act, TRACED. This was the same bill that was introduced in November of last year. This bill significantly focuses on enforcement and fines and penalties that would be leveraged against violators of the law. So a provision that broadens so it includes a provision that would have broadened the FCC's authority to levy civil penalties of up to $10,000 per call against violators who intentionally disobey the restrictions. And it has a provision requiring providers of voice services to adopt call authentication technology, which would enable a telephone carrier to verify incoming calls are legitimate and could be passed through to consumers. And then it would also expand the TCPA enforcement powers to other agencies within the government, including the Department of Justice, the Federal Trade Commission, the Department of Commerce, the State Department, Department of Homeland Security, and the Consumer Financial Protection Bureau. And then lastly, on November 13th of last year, the U.S. Supreme Court granted cert in a case, Carlton and Harris Chiropractic v. PDR Network, after the Fourth Circuit vacated a lower court ruling regarding what constitutes an unsolicited advertisement under the TCPA. So the significance here is that the Supreme Court is set to review whether the Hobbs Act requires district courts to accept the FCC's legal interpretations of the TCPA. And this ruling may bring some uniformity to the judicial deference that federal courts afford to the FCC's TCPA rules in civil litigation. And significantly, this could have ramifications for any forthcoming FCC rulings on what constitutes an ATDS. So there was a lot of talk last year about caller ID spoofing. This has been a significant focus for regulators and the industry, and particularly last year. So in May of last year, the FCC imposed a record $120 million fine on a robocaller for placing nearly 100 million spoofed calls. And in September 2018, the FCC proposed a more than $37.5 million fine against a company for making more than 2.3 million malicious spoofed telemarketing calls. This one is not a final amount, but it's just what the FCC has proposed. So it wouldn't go any higher than that amount. It could, in theory, go lower than that. So in January of this year, the FCC issued a notice of proposed rulemaking to comply with legislation that was enacted in the Ray-Bombs Act, which was signed in March of last year. So the law made several changes to the way the FCC should operate, including increased scope of caller ID spoofing prevention measures that will be enforced by the FCC. The multiple states, including Connecticut and West Virginia, passed anti-spoofing laws over the course of last year, and Connecticut made it a criminal offense. Historically, states have run into problems with some anti-spoofing laws being preempted by the Federal Truth in Caller ID Act. So many of the laws that have been enacted in the past have just closely tracked the federal law, though the West Virginia one is more expansive than the federal law at this point. And then lastly, just in January of this year, T-Mobile launched its new call verification technology, which will confirm that a phone call is actually coming from the number listed on the caller ID. Now, if a T-Mobile subscriber calls another T-Mobile subscriber, the person receiving the call will see a message saying caller verified if they have a supported phone. Of course, there are a lot of limitations at this point on this, given that it's only one service who is providing this, and you would need to have a T-Mobile subscriber on both ends. But things certainly seem to be moving in that direction, and there may be other carriers in the future as well. So I mentioned, talked a little bit a few minutes ago about the DC Circuit's decision last year with regard to what constitutes an automatic telephone dialing system. Since that time, there have been other decisions with regard to this, and I'm going to highlight two. In October of 2018, the Ninth Circuit ruled on what constitutes an auto dialer. And the Ninth Circle panel held that an ATDS is any device that stores telephone numbers to be called, whether or not the numbers were generated by a random or sequential number generator. So this is a broad definition of an ATDS. This was contradictory to the Third Circuit's decision from June of last year, in which the court rejected the TCPA claim because there was no genuine dispute of fact that the defendant's device lacked the ability to generate random or sequential numbers and dial those numbers. While the DC Circuit's opinion was hugely important last year, it didn't make a call one way or the other with regard to what actually is an ATDS. And so that's why you're still seeing courts coming to different decisions in different circuits and at the district court level. So at this point, there is a split in the circuit, and at this point, it's just stay tuned.
Thanks, Marissa. Before we move to the state portion of the presentation, I want to provide a few quick recommendations. I think from what we've seen, it's pretty clear that risk still exists for companies that wish to use the phone to engage prospective or current customers, and that risk is only magnified if technology is used to facilitate those calls. The first recommendation is do not call safe harbor. I'm sure many of you are aware of the do not call safe harbor. This exists under the FCC's Telephone Consumer Protection Act, as well as the FTC's telemarketing sales rule. It essentially says that if you have these 5 components in place and you have an error or technical issue in your compliance processes, you'll have a defendable position to show that you were intending to comply in any issues were the result of that error. So these 5 components are first, written guidelines. So this is simply documenting your policies and procedures for complying with the applicable rules. You then need to make sure that you train on those guidelines. So this includes new hire training when people are onboarded before they place or receive any calls on your company's behalf. And then you need to make sure you refresh that. So this could be annual refresher training for all employees and as needed for employees that seem to be struggling with adhering to the rules. The next component is you need to make sure you honor consumer opt-out requests. So this is typically referred to as an internal do not call or a company specific do not call list. And this is essentially a list of consumers that have opted out of further calls from your company. You need to make sure you have a process to accept and honor those requests. The next piece is DNC suppression. So there's a variety of do not call lists that are out there, including the National Do Not Call Registry, several state do not call lists, your own internal list, and then the wireless list. You need to make sure that when required, you are accessing and suppressing against those lists. And then lastly, you have to monitor and enforce compliance. So all of this is great, but if you're not monitoring for compliance on an ongoing basis, this can lead to issues and potentially liability for your company. The next recommendation is in regard to the use of auto dialers. Auto dialers can be great. They provide a lot of benefits, including increased efficiency for your team. And they can also facilitate compliance by allowing you to set the dialer to comply with certain requirements, such as calling time restrictions. But if you're going to leverage that technology, you need to make sure you know how to do so responsibly and appropriately. First, if you're using it to call consumers, likely cell phones, to sell or market any goods or services, you need to make sure you have the appropriate level of consent. And the regulations are very clear about what components need to be in that consent disclosure, and we've provided them here. If you have any ambiguity as to whether your dialer system would be considered an auto dialer, and we could understand if you do based on the cases Marissa just reviewed, we would recommend that you get a third-party opinion. If you're going to try to claim that your system is a manual dialer and it doesn't have the capabilities of an auto dialer, have an expert come in and evaluate that and document that in case you ever need it to demonstrate compliance. All right, so now we want to move back into the review, and I'm going to ask Paul to walk us through what we saw at a state level in 2018 and moving into 2019.
Okay, first we'll start with some of the key regulatory changes at the state level in 2018. The first change occurred in Florida that we'll cover, and that has to do with ringless voicemails. So that's an instance where a consumer would see that they have a voicemail on their phone, but the phone, in fact, it never rang. Florida has now banned those messages. They essentially deem them to be equivalent to a pre-recorded message. Therefore, without the proper consent to send a ringless voicemail, those types of messages would be banned in the state of Florida. And we think that more states may follow. This is really just a scenario where technology has outpaced the legislation. Next, Connecticut has made it a requirement to immediately disconnect a telephone call when a pre-recorded message is delivered to a customer and that customer hangs up the phone. And the whole point behind this is to make sure that the pre-recorded message does not tie up the consumer's line after they hang up the telephone. So when calling into Connecticut, ensure your dialer settings are appropriately set to disconnect calls immediately. And then finally, rather some good news in the state of Illinois, they repealed a portion of their do not call regulations. And what that did essentially was open up the inquiry established business relationship timeframe to be equivalent to the federal level of 3 months. Previously, Illinois was a 1 month inquiry timeframe. And again, they're now at 3 months to have an exemption to calling numbers on the national do not call lists. So we just spoke regarding Florida ringless voicemails, and the first interesting enforcement that we'll cover has to do with ringless voicemails in the state of Michigan. A Michigan judge ruled that such messages are actually covered by the TCPA. meaning that a direct ringless voicemail, or otherwise known as a voicemail drop, if that were to be sent to a consumer, you would also have to have the adequate consent in the state of Michigan as well as the state of Florida. Massachusetts enforced its rule of only allowing 2 debt collection calls in the 7-day period. Really, a court case occurred where a collector called 4 times to a consumer's telephone. They did not leave a voicemail and argued that because no voicemail was left, that did not constitute a telephone call. However, Massachusetts disagreed and enforced that regulation that has been in place for some time. Michigan, one court denied arbitration for a consumer who received a collection call because the wife was the provider of the telephone number of the husband who received the collection call. So in other words, the wife provided her number as well as the husband's number on an application to a company. The company attempted to collect on a debt to the husband's telephone number. Because the husband did not provide the number and was not the authorized user of the account, and he sought damages for those collection calls, and the court agreed that he did not have to go through arbitration and that he was entitled to receive damages outside of arbitration because he was not the consenter of the telephone number. Finally, a West Virginia court ruled that a communication service provider could be held liable for the actions of its clients. And in general, a service provider is someone who provides platforms to send VoIP calls, emails, pre-recorded messages. Perhaps it's a dialer company. And really, under the FCC and the FTC, we've always heard that of accomplice liability, vicarious liability, and really that's more of a seller and a third-party telemarketer scenario. So this was interesting in that it was a communication service provider. And so we often advise our clients to have strong contracts in place, adequate record keeping, monitoring, enforcement, things that Matt had just discussed in the previous slide, in order to avoid any sort of liability that could result from your business partner's actions. So quickly, we'll go through just some of the lessons learned. New York is beefing up their do not call enforcement staff. Last year, their complaints doubled to 500,000 regarding telemarketing calls, and only one of those cases was referred to for further investigation. And they claim the reason for that was because they were just vastly understaffed. So they're going to be hiring in New York for their DNC enforcement staff. We just discussed vicarious liabilities occurring at the state level too. We know that the FCC and the FTC have expressly held companies are responsible for the actions of their business partners, and we now see that that is also translating to the state level as well. And then finally, express consent must come from the user of the phone. We're really often asked, do referrals, meaning if a consumer were to provide their neighbor or their roommate or otherwise, if they were to provide a cell phone number on someone else's behalf, does that consent transfer over? And the answer to that question is no. And then we see, based on the case in West Virginia, that it actually goes one step further to the husband and wife scenario. So we want to make sure that we're getting consent from the user of the phone that we intend to call. Next, we'll cover some potential regulatory changes coming in the pipe in 2019. The first of which is the state of New York. They have proposed to ban telemarketing calls during states of emergency. Right now, Louisiana is the only state that outright prohibits telemarketing during a state of emergency. And New York is likely soon to follow. And really, most of our clients generally follow a best practice of, if there is a state of emergency within a state, then they just go ahead and prohibit telemarketing calls into that state until the emergency is lifted. And then next, Indiana, New York, and Washington are looking to penalize companies that move their call centers outside of the US. And so what this means is, if a company were to relocate a call center, they could be disqualified from receiving loans, grants, tax credit. In some cases, it may require notice to the state prior to moving outside of the US. And so let's take a look at some anticipated focus in 2019. And what we think that is going to be is robocalls. Everyone loves robocalls. However, we think there's going to be a focus to stop those. In 2018, there was 47 trillion robocalls sent in America. That was a record number. And in January of 2019 alone, there's 5.2 billion that have been sent. And if you do the math, that's roughly 16 pre-recorded messages per person in the United States. Right now, there are 40 state AGs that are working together to figure out how to reduce the robocalls into their states. They're trying to determine what is technologically feasible. They're also engaging with telecom providers to figure out a solution. So they're working in collaboration with these telecom providers. And lastly, they're evaluating whether or not they should be providing recommendations to the FCC on how to strengthen regulations surrounding robocalls.
All right, Paul. So thank you for the update. And I think we can all agree 2019 is going to be the year of the robocall. When we look at 2018, I think you could call it the year of privacy and data security. There were several high-profile data breaches. There was a very stringent privacy regulation that went into effect in the EU. That was the General Data Protection Regulation, and we'll talk about that more in a moment. We saw some US states and cities actually begin to propose some privacy laws, and a few begin to implement them. The US government actually even got more active with enforcing an existing privacy law related to children's privacy. And so I'm going to turn it over to Marissa, who's going to talk about that in more detail.
Yeah, so we'll start with talking about COPPA, which is the Children's Online Privacy Protection Act. And certainly COPPA has been in effect for much longer than starting in 2018, but there were some key enforcement actions in 2018 that are worth talking about and drawing our attention to. Before we do that, I'll just do a super high level overview of COPPA and its requirements. So the law was enacted in 1998 and it went in effect in 2000. And it applies to operators of a commercial service or online service, and it's the key is websites and online services that are directed at children, or a website or online service that has actual knowledge that they're collecting information from children. COPPA protects personal information of children, which has a broader definition than you might think. It includes things such as usernames and even persistent identifiers, such as a device ID. So sort of beyond, your typical name, social security number, some of those other things that we associate with personal information in this country. The law can be enforced by both the Federal Trade Commission and state attorneys general, which we'll see in just a minute. And it's one of the only consumer protection areas where the FTC has rulemaking authority, and it can get very high fines, unlike in most other areas that the FTC enforces. So the key requirements of COPPA are that you must notify parents before collecting personal information from children. You must get verifiable parental consent before collecting personal information from children. And this has to come via one of the approved methods. You have to allow parents ongoing rights to amend or withdraw consent, and you must implement reasonable security measures for personal information from consent from children. The parental consent piece is particularly challenging. It's much more specific than just emailing a parent a consent form. The fear is that a child could enter in their own email address, and so you won't actually know whether the parent is consenting. So there are companies and vendors out there that can assist with this, but this is a particularly difficult area for companies, but also one that's very important for companies to get right, given the high risk of fines and high enforcement. So speaking of enforcement, last year, in December, Oath, which was previously known as AOL, had to pay the highest fine ever for violating COPPA, $4.95 million. the largest COPPA enforcement matter in U.S. history, and they had to adopt comprehensive reforms to protect children from improper tracking. The Attorney General's office found that Oath had conducted billions of auctions for ad space on hundreds of websites the company knew were directed at children under the age of 13, and that through these auctions, Oath had collected and used and disclosed personal information from children in violation of COPPA. There's a couple of significant things to think about with regard to this action. One is just note that it's from the New York Attorney General. It's not the FTC, which is showing the state attorney generals getting much more active in COPPA in recent years. I think there's some thought with the current makeup of the Federal Trade Commission that there won't be as much enforcement in the privacy space. And so state AGs are sort of filling that void. And that was particularly true for a while when we didn't have all the commissioners. And so there just wasn't that much going on at the FTC. And so the state attorney generals were filling that void. The other thing to note about this is that there's becoming much more of a focus on the ad space. So going after the ad exchanges, not just the websites or the app, which is actually collecting the information. So here it was Oath who wasn't operating the site, they were operating the ad exchanges. And then a couple of more enforcement actions we've noted on here. You'll see another new Attorney General action, this one by the New Jersey Attorney General. And then the VTech one is worth noting because it was an internet connected toy that was collecting information without consent. So that's another area that companies need to be focused on. If their toys are collecting, a recording from a child and then it's connected to the internet, that this could be a violation of COPPA. The other significant thing about the VTech case was it was a security case as well. In addition to being COPPA violations, it was a failure of the company to have adequate security in protecting the information that it had collected.
Thanks, Marissa. Now we want to briefly switch gears to the EU to talk about the General Data Protection Regulation. I think it's impossible for us to do a regulatory update without at least talking about the GDPR. I would assume or hope that everyone on today's session is familiar with the GDPR. You definitely should be if you have employees or customers that are EU data subjects, or if you're a service provider for companies that may have those employees or data subjects. We want to just review it briefly because we're starting to see a ripple effect in the US, we believe, which is a result of the GDPR. So it went into effect in May 2018, and it's really become the gold standard in terms of privacy and data security regulations. It really empowers consumers with control over their data. Companies are now required to be transparent about the data they collect and how they intend to use it. There are a ton of requirements under the GDPR, but we just want to talk about a few of them today. First are the data subject rights. There's 7 data subject rights. A couple key ones are the right to access. So this is just giving the consumer the ability to see what data the company has on them. And next is the right to erasure. So this is giving the consumer the ability to request that the company delete any of their data. There's also a requirement to have a data protection officer based on the processing activities that your company may be performing. If you're required to have a DPO, they would have a variety of responsibilities all geared around privacy. In particular, they need to be able to report to the highest level of management. They need to have independent authority, so essentially the ability to make decisions regarding data processing without any influence from the business. And importantly, they cannot be penalized for those decisions. So this role is really empowered to protect consumer data. And because of that, they need to make sure they're involved in all discussions related to data, as well as any activities regarding changes to products or services that would impact how data is processed by that company. I think ultimately it makes clear that companies now have to be good stewards of the data that they collect. The GDPR has some very significant teeth to it. The penalties are up to 4% of annual global revenue or 20 million pounds, whichever is greater. And we are now starting to see it enforced. And so it's important that if you're not sure if the GDPR applies to you or what's required, that you evaluate its applicability to your business and operations. The reason we wanted to touch on it today is we are starting to see the effects in the US, not only with companies that are under the scope of the GDPR because of their activities, but also because of activity at both the federal, state, and city level when it comes to proposed and some recently implemented legislation. So I'm going to turn it back over to Marissa to tell us what she's seeing at that level.
Thanks. So historically, the US has not had, as most of you probably know, a comprehensive data privacy law. It has been sectoral, so there has been enforcement in depending on what area you operate. So if you're in healthcare, there have been, there was HIPAA, and then there was Gramm-Leach-Bliley for the financial sector. Now with GDPR, the US has started focusing much more on sort of whether it should have a comprehensive privacy law. And we will talk in a minute about sort of the efforts that are underway at the federal level to pass a comprehensive privacy law. But California, as a first mover, has already passed its own privacy law. The CCPA was signed into law on June 28th of last year, and it was drafted and enacted or signed into law after only a week of discussions and drafting in order to fend off an even stronger ballot measure. And by contrast, GDPR took years to write. So the law still has some changes that we expect to happen before it actually goes into effect, which is currently it's going to effect on January 1st of 2020, but will not be enforceable until July 1st, 2020. So there have already been one set of revisions to the law, which came in September of last year, and we expect there will be some more. So we just heard about the different rights that are provided under GDPR, and there are some similar rights that are written into the CCPA. So there's the consumer right to know. So under the CCPA, similar to GDPR, California consumers have a right to request what personal information has been collected about them, as well as what personal information has been sold or otherwise disclosed about them. There's the right to delete. So California consumers have a right to request their personal information be deleted. And there's an opt-out from sale of personal information right. So California consumers are afforded the right to opt out of the sale of personal information. Personal information under the CCPA has an extremely broad definition. So it's important to sort of understand what the law actually applies to. So whether the extensive CCPA requirements will apply to various types of information that a business holds hinges, as I just mentioned, on this broad definition of personal information. And the definition covers an array of data, even when it's not tied to actually identifying a person. For example, personal information also encompasses data that relates to or is capable of being associated with or could reasonably be linked directly or indirectly with a consumer or household. So there are some exemptions for entities and information that are regulated by other laws, such as the Gramm-Leach-Bliley Act and HIPAA, but entities that are covered by those laws should not assume that they won't be subject to CCPA, as depending on, particularly if you think about HIPAA, while entities that are regulated by HIPAA may be exempt, not all information that such entities process is necessarily exempt. So it's really important for companies to understand whether the law applies to them or not. So the law is currently, as we mentioned, going in effect in January 1st of next year, but important to look out on any changes that we think that may come down the pipeline over the next, throughout the course of 2019. Which may sort of change the scope and what types of information applies to them, what types of entities it applies to. So as an overall look at the privacy landscape and think what has changed in the last year. So now all 50 states plus DC, Puerto Rico, Guam, and the Virgin Islands all have data breach statutes. Alabama and South Dakota were the last two to implement laws, and that happened last year. And states are still changing their laws. They're not set in stone. So one of the things that we've seen is that some states are starting to pass mandatory credit monitoring for certain types of breaches. So Massachusetts, Connecticut, and Delaware all have mandatory credit monitoring when a Social Security number has been breached. Just touch on a couple of additional laws that were passed last year. So California passed a cybersecurity law requiring reasonable security measures for Internet of Things. So when it takes effect in January 2020, it will require manufacturers of internet connected devices to equip the devices with reasonable security features designed to protect against unauthorized access, destruction, use, modification, or disclosure. Although the law is pretty vague as to what constitutes a reasonable security measure, there are some broad parameters provided in the law and examples of specific approaches that may satisfy the requirement. There are also a couple of laws that have been passed, or at least the one in Vermont has been passed, and then one that's been proposed in Washington State with regards to data brokers. And the focus on these has been on requiring these types of entities to implement adequate security programs to protect data that they have in their possession. So the big question of the year with regard to privacy is whether we will see a federal privacy law. And the California Protection Act that was passed has spurred much of the discussion about this. And the real question is whether a law will be passed that will preempt the California law. Both parties, Republicans and Democrats, are interested in enacting a law that includes affirmative rights for consumers, much like the ones we've talked about in CCPA and the GDPR, including the right to access data a company has about them, the right to correct it, the right to delete it, and then the right to be able to move it from one firm to another. But a big question is whether any law that's passed will preempt the California law. Republicans so far seem determined that any federal law will preempt the California law. And while Democrats are not necessarily against that, it's the big caveat for them is that whatever replaces the California law must provide at least the same protections as the California law. So Senator Marco Rubio recently introduced the American Data Dissemination Act, the ADD, and which is largely seen as a response to the CCPA. The ADD is largely devoid of specific data privacy regulations. It instead requires the Federal Trade Commission to submit detailed recommendations to Congress within 100 days after the bill is passed. And then if Congress fails to enact the FTC's recommendations within 2 years, then the law would give the FTC the authority to issue a final rulemaking, which most would say realistically that means within 2.5 years of the bill becoming law, there would be a privacy law in the United States. So Rubio's law is just one of a number of attempts by senators to try and improve privacy legislation. Senator Blumenthal, who has been a big privacy advocate, he has indicated that he plans on introducing a privacy law early in 2019, but we haven't seen that yet. So, I think when the CCPA was first passed, there was a lot of thought that we would have a piece of federal privacy legislation that would be passed before the law goes into effect. Now that we are, less than a year away, it is seeming unlikely that there will be a federal law in place prior to January 1 of 2020 when the CCPA goes into effect. And so while companies were sort of in a wait and see posture over the last 9 months since the CCPA was first passed, that's really not an option anymore. It's important for companies to start actually thinking about how they are going to comply with the law, because it looks like it's coming, and they're going to have to figure out how they're going to comply with it.
Yeah, we agree. Whether it's the CCPA or other U.S. privacy laws, I think it's clear that something's coming and companies need to make sure we're prepared So what we wanted to do is just spend the last few minutes giving a few recommendations based on our work helping companies get ready for the GDPR in 2018. First and foremost, companies need to understand their data. They need to understand the data they collect and how they process that data once it's in their possession. Often this is something that companies struggle with out of the gate. And so really the first step is creating that data inventory and data map so you can understand what data do you have, who owns it, and where does that data flow. This will allow you to respond to the subsequent requirements that we see in some of these privacy laws. We also recommend, and you see this in the GDPR, that companies follow the principle of data minimization. So don't keep the data if you don't need it. Don't collect it if you don't need it. We recommend that you evaluate all of your data collection and processing activities as well as your data retention to make sure that you're only collecting and processing the data that you need to in order to perform your business. The next recommendation is understand your vendor and third-party network. This network is going to be critical as you begin having to respond to some of the requirements in these privacy laws, particularly the requirements to delete an individual's data or give them access to their data. So it sounds basic, but first and foremost, have a list of your third parties. Identify who they are, what activities they're performing on your behalf, and do you have a contract in place? And if so, does that contract address data security appropriately based on those activities that they are performing? You also might want to consider mandating their assistance responding to some of these data subject rights, such as the right to delete or the right to erasure or the right to access. If a request like that were to come through, you want to make sure that the applicable vendors are responsible for working with you in the required time frame to honor those requests. And then lastly, you want to make sure that you monitor them. So if they are processing data on your behalf, go visit them, make sure they're doing it securely, make sure they have the necessary policies and procedures and controls in place to protect your data. Ultimately, we think you can't have privacy without data security. And so not only do you need to make sure your vendors are doing it securely, you need to make sure you're also handling your data in a secure way. And so what we recommend is companies evaluate implementing an information security management system. This could be ISO 27001 or some combination of NIST 830 and NIST 853. But it's important that companies have a plan and a framework that they can put in place and rely upon for both technology controls and educating and managing their employees to avoid any potential loss or breach of that data. Unfortunately, breaches are going to happen, and the GDPR in particular actually has steps companies have to follow if there is a breach. So it's important that you understand what's required in that situation and that you have a plan for if and when it occurs. So if you don't have one, develop that plan, test it out internally, make sure it's implemented, and then periodically review it. So test it with your employees and your executives and modify that plan on an ongoing basis based on the results of those testing activities. So I know we've covered a lot when it comes to privacy and a lot of that at a high level. If you'd like more information about the CCPA and other privacy laws, we actually will have a webinar next month and we'll be sending out invitations shortly. So keep an eye out for those. With the time we have remaining, we'll do our best to answer as many questions as possible. As a reminder, if you have a question, please enter that into the chat function now.
Everybody, thank you for taking the time to join us today. Marissa is remote and unfortunately is not able to answer the questions via audio. But if you have a question for Marissa, please enter that into the chat box and she'll do her best to answer those as time permits. A couple quick things I want to mention before I dive into a few of the questions we received. First, if you would like to learn more about CCPA, we have the CCPA webinar coming up next month on March 20th at 2 p.m. Eastern. We will be providing a link to that webinar following the event if you would like to go ahead and register for it. Also, some people have asked about a copy of today's materials. Following the event, in that follow-up email, you will receive a link to the video and audio portion of today's event.
One thing I want to touch on before we get into some of the recent privacy questions is we've got a couple questions around auto dialers and if we're using click to call or manual dial, could that be considered a dialer? So Paul, can you first give us just a few quick thoughts on what companies should consider with their dialer technology?
Yeah, really what companies should consider is the capacity of what their dialing system can do. So what does that mean? If you're able to predictively dial, progressively dial, or work from a list of numbers and have the dialing system go from one number to the next in an automated function without human intervention, again, if you can do that, that's really what you should focus on, and not necessarily the fact that a call was placed via click to call or if a number was entered. And that's because really the courts are pretty erratic on what they're deciding as to whether or not a dialing system is considered an auto dialer. So bottom line, evaluate the capacity and not how you dialed a phone number when you're looking at your dialing system.
Yeah. One thing I do want to mention, we got a few questions regarding links to particular sites or articles for more information about some of the content we've covered today. We will provide you with our contact information for all the presenters, and so feel free to reach out to any of us directly, and we can work with you to follow up. So one question we got on the privacy side was around data minimization, and it was a question asking about, is it okay to keep historical data for analytics? And this is where we're starting to see the evolution. So historically, yes, you could keep that data and really leverage it for whatever purposes you needed to. But starting with the GDPR and now with the CCPA and some other state laws we're starting to see proposed, that's going to change a bit. So first and foremost, you're going to be required to disclose to the consumer when you're capturing that data what you intend to do with it. So if you're going to be using it for analytics on the back end, you're going to have to provide that information on the front end when capturing the data. You need to make sure you're securing it as long as it's in your possession. And then if you intend to use it on the back end, again, that would be okay as long as you're providing that disclosure, but you need to be prepared under a lot of these laws to delete it if the customer initiates such a request, or at least provide that information to the consumer if they ask what data you have on them. So that's a common theme in a lot of these privacy laws. What we mean with data minimization is be smart about the data that you're keeping. So understanding the need to use it for analytics, you may want to keep that, but really look at all the data elements you're capturing and storing and ask yourself, does this pose a risk to us if we keep it and process it? And ultimately, is there a value to us by collecting it, keeping it, and processing it? If there's no value, our recommendation will be then don't collect it in the first place, because it could just pose a risk to your company to, again, store it and secure it and treat it responsibly.
Okay, it looks like we got a question regarding the question is, how can phone companies stop a wireless message if it becomes a informational service? And so what that means is right now, or previously, a wireless message, a text message, was considered a telecommunications service, and under the carrier's rules, they were not technically allowed to block a telecommunications message for a variety of reasons, including the First Amendment in freedom of speech. But now that it is considered a wireless message, it is now empowering, again, the key word is just empowering the telecommunications carriers to block a message if they think it's a fraud or spam message.
All right, so I know we've gone a little bit over our time. We had one last question that I can answer here quickly. And again, please leverage our contact information for any additional questions. But the question was in regard to some of the security frameworks that we suggested in the privacy section. So that was, ISO has a lot of frameworks. There's ISO 27001 you could look at from an information security standpoint. And with NIST, it could be a combination of NIST 830 and NIST 853. So for the individual that asked that question, if you'd like to discuss those frameworks in more detail, just let us know. Thank you all again for taking the time to join us today. We hope to see you next month